Good morning, everyone. Thank you for joining us. We're here today to talk to you about AI, in particular, the implementation of the recent EU AI Act and the relevant risks that this may cause for you and your business. Now, to be clear, we're not just going to be focusing on the risks presented by the AI Act. We're also going to be talking about AI systems more generally and the risks that they present. Given the recent increased adoption of AI systems, clearly this has led to an increase in risk, both in supply chains, risk posed by employees, and risks in the market generally. So we're here to help and guide you through those risks and provide you some guidance around what you can do to remediate those risks. First of all, to introduce myself, so my name is Matthew Lingard. I'm a director in the intellectual property and technology team at Walker Morris, and I'm joined today by my colleague Paul.
Morning, everybody. My name is Paul Armstrong, and I'm a tech lawyer here at Walker Morris.
Now, before we dive into the content, just some housekeeping. We're going to do our best to keep to time. If you do have any questions throughout the talk, please do pop them in the chat function. If we have time at the end, we will address them. If we don't, we will follow up with you afterwards. And obviously, if you do have any questions following the talk generally, do feel free to reach out to myself and Paul. So we're just going to go to the next slide, looking at what we're going to talk to you about today. So, first thing we're going to do is just have a very quick introduction about what we mean when we talk about artificial intelligence. We always feel that when we do any talk relating to a tech-related subject, that it's important that we all get on the same page so that we all understand what it is we're talking about, or else the rest of the talk is going to be slightly harder to follow. We're then going to talk about the implementation of the recent EU AI Act and the impact that could have on your business. We're then going to talk about AI-related risks more generally. So what risks are presented from a contractual perspective, from your employees, from your supply chain. And then we're going to talk about what you can do to both prepare for the new regulations, along with preparing for the new risks presented by AI more generally. Now, artificial intelligence. As promised, we're going to do a brief introduction as to what we mean when we talk about artificial intelligence. So artificial intelligence is nothing new. It's been around and it's been embedded in technology for many years. You only have to take a look at your smartphone and the various functions that it offers to see that there are lots of these tools already embedded in our day-to-day lives. One such example, if you take a picture on your phone, the reason why you have multiple lenses on your phone is that photo phone will take roughly 100 images per shot. Then there's a sophisticated tool in your phone which will then put those together and put you a nice selfie together that you're happy to then share online. AI systems, more recently, AI systems are being seen as replacements for people. So the more recent developments in AI, so the ones that we're talking to you about today, these are the generations of AI systems which allow them to think and solve complex problems. This has allowed AI systems to step out of the back room of technology and more into the front room of day-to-day operations. These recent tools include tools such as ChatGPT, Grok, and Google's Gemini, and there are many others that I'm sure you can read about and have heard about in the press. Now, the recent EU AI Act has given a very set definition of what an AI system is, and I'm going to read that to you verbatim now because it's too long for me to remember off the top of my head. So an AI system means a machine-based system that is designed to operate with varying levels of autonomy and that may exhibit adaptiveness after deployment, and that for explicit or implicit objectives infers from the input it receives how to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. Now that's a very long definition, and don't worry if you didn't understand that or didn't follow that. It's taken us quite a while to grapple with that as well, and there have been many criticisms of that definition. As recently as last week, the EU Commission on AI published a 13-page guidance document solely on that definition. And that may say something about the quality of the drafting of the definition there. And to be honest, me and Paul are still getting to grips with that 13-page guidance around the definition. So once we have got a firmer understanding of where that sits, we'll be in contact. So don't worry if it doesn't quite make sense just yet. So why are we talking to you about AI now? And why weren't we talking about AI systems, 10 years ago? Well, it's important to say that there's been huge advancements in the quality of AI systems, which has allowed them to start doing these problem-solving tasks in a manner which seemed far more legitimate. In times gone by, utilising these tools would have been obvious, the outputs would have been relatively simple, and the quality just wasn't there. Whereas recent investment and advancements by companies such as Google, Microsoft, mean that these tools are now far higher quality and are finding their way into the business ecosystem. Now, what is the EU AI Act? Well, following the generation of these tools and the increased implementation of these tools in both business and society in general, there was a demand for, or a suggestion that new rules were required. The EU launched a commission and a listening project, which over time then resulted in the implementation of the EU AI Act. The EU AI Act is the largest single piece of regulation governing AI in the world today. We still don't have its equivalent in the UK. However, regulators are currently working to come up with a set of rules. The main aims of the EU AI Act are to both protect the public and to increase the level of trustworthiness in AI systems through managing the various risks presented by AI systems. So what is the impact on business? So who will the EU AI Act affect? Now, you may be sitting there thinking, why are we talking to you about a piece of EU legislation when the majority, we think, of our listeners are based in the UK? Well, it's important to say that the Act has extraterritorial effect. That means that any AI system that's used in the EU will need to comply with the AI Act regardless of its source. So if you are a company which is using, or to use the terms of the Act, deploying an AI system as part of your business offering, and you have customers based within the EU or customers that could be based within the EU, this will bring you within reach of the Act. Now, it's important to say that even if you're not impacted by the Act already, that as the regulatory landscape in the UK is still relatively uncertain, that we certainly think that it is sensible that all businesses should start at least addressing the risks presented by AI systems generally. Now, UK regulators have not set in stone which way they're going to go with the regulation, but given that harmonisation is always sought as part of a wider regulatory regime, especially with a global issue such as AI systems, we would expect that any regulation brought into the UK would be softly harmonised or could be completely harmonised with the EU. Therefore, we think it is sensible, given that the guidance set out by the Act appears sensible, to begin aligning your business with the rules and requirements as set out within the EU AI Act. In addition, there's some more general guidance, which we'll come on to later in this talk, around preparing your business, your employees, your supply chain for the risks presented by AI systems. And we think that is just good sense generally to help your business manage the risk posed by this new technology. Now, turning to the application of the Act, one of the main considerations when we look at the Act is whether you are a provider or a deployer. Now, Paul's going to take you through that in more detail in a moment, but it's important to say that we imagine the majority of you listening will be classed as deployers. Providers, as defined under the Act, are the ones who are actually coding the tools and creating the AI systems that people then are subsequently deploying out to their customers. Given that, from our knowledge, there's only a relatively few number of businesses who are currently in the business of developing these very clever, cutting-edge tools, congratulations if you are one of them, we would imagine that, as I say, the majority of you are deployers. So this is taking an AI system, which a third party has created, and then putting that to use within your business, either for internal purposes or potentially as part of your business offering for customers. That would class you as a deployer, and that would bring you within the requirements of the EU AI Act, if you are caught by the scope of the territory, as mentioned before. Now, what does the AI Act actually do in simple terms? So from our perspective, there's three broad heads of what the AI Act is attempting to do. The first thing is it requires all staff who are employed in either the development or the deployment of AI to be AI literate. Now, the thinking behind this is that in order for you to be able to comply and reasonably comply with the requirements of the Act, your staff need to have that basic level of knowledge to allow them to be able to issue, spot, and understand what they're doing. So the wording of the Act requires that all staff have the skills, knowledge, and understanding that enables for them to make informed decisions. This then makes them aware of the relevant opportunities, the risks, and the potential harms posed by the AI systems. This AI literacy requirement is one of the key cornerstones of the Act, and In our view, it's one of the key remediations that most businesses will need to put into effect. The reason why we're saying that you need to put them into effect, if you look to the far side of the slide, or the other side of the slide, you'll see that there are strict financial penalties for non-compliance with the Act. Very similar to the recent GDPR regime that was brought in, which is policed by the ICO, there are very strict financial penalties for failing to comply with the Act. Again, similar to the GDPR fines and penalties, these can result in fines of up to 35 million euros, or up to 7% of annual turnover, and these are clearly very significant. It's unclear at the moment who is actually going to enforce the terms of the EU AI Act, as there has not been an equivalent regulator at this moment in time set up to enforce the terms of the regulation. Therefore, at the moment, we would expect this to happen as a result of kind of third-party private prosecutions. However, in the event that a regulator is set up, or should you find yourself on the receiving end of third-party prosecutions, as discussed, the penalties can be quite severe. Now, turning to the actual meat of the Act, the risk classification system. So, the key aim of the Act is to take a risk-based approach to the regulation of the AI system, and it does this through classification of the system itself. Once the system has been classified, you then are able to apply a commensurate level of risk. My colleague Paul is going to take you through those levels of risk and what they mean for you and your business.
Excellent, Matt. So there's a huge emphasis on risk in the Act, and I think it's probably worth thinking about what exactly does risk mean in the context of the Act. And basically it means the risk that AI systems pose to the health, safety and fundamental rights of EU citizens. And when quantifying the risk, basically you need to look at the probability of some harm occurring and the likely severity of that harm should it arise. And that's the backbone of the risk classification system. And as Matt's mentioned, different AI systems have different levels of risk. And you can see there on the slide the four main risk categories. The first category is prohibited AI systems, and they are, as the name suggests, AI systems which are deemed to pose an unacceptable level of risk. Therefore, they shouldn't be used in the EU at all. Next, you've got high-risk AI systems. Then you get down to limited risk AI systems. And then finally, you've got minimal to no risk AI systems. Now, one of the key points to make is that the AI literacy requirement that Matt was talking about earlier on, that applies to all of the different risk classifications, and that's important. The Act also talks about general purpose AI models as something separate to an AI system. I'll talk about that distinction in a little bit later on, but for now, it's just worth calling out that there are specific rules that apply to general purpose AI models, and there's a risk classification around those models as well. So you've got sort of the normal general purpose AI model, if you like, and then you've got general purpose AI models that, for the purposes of the Act, are deemed capable or likely to create some form of systemic risk. The other factor that's really important when it comes to risk classification is the role of the organization that is actually using the AI system. And by role, I mean the role of the organization within the overall supply chain for the AI system itself. And as Matt's already mentioned, provider and deployer, in our view, are the two main roles. So I'll talk about the specific rules that apply to each of those different categories. But just drilling into the detail a little bit, what is a prohibited AI system? Well, there's various different categories. The first one is an AI system that's being used for some form of biometric categorization to infer characteristics about individuals, such as their race, their political opinions, their religion, etc. Another prohibited use case is using an AI system as a form of subliminal influencing that is going to distort a person's behavior, basically by impacting their ability to make informed decisions in a way that's likely to cause them significant harm. Another prohibited use case is the use of AI to exploit the vulnerabilities that a person has or the vulnerabilities of a particular group. Now that might be based on a disability or on potentially other factors. Using AI to exploit that type of person in a way that's distorting their behavior and causing them harm is something that's prohibited. And the Act also talks about emotional recognition systems, and emotional recognition is a kind of form of facial recognition. It goes a little bit wider than that, but if you think about it in those terms, and what the Act says, well, look, you can't use emotional recognition systems in the workplace or in an educational institution unless you're doing so for specific medical or safety reasons. Now, the prohibited AI systems that I've just been talking about they've been banned outright as of earlier this month. The EU, just over the past couple of days, has put out a 140-page guidance document on some of the detail in what I've just described. But that aside, the situation is pretty straightforward when it comes to prohibited AI. In the hopefully unlikely event that you're using AI for any of those purposes, and I think most right-thinking people would think that AI shouldn't be used for those purposes. But anyway, in the unlikely event that you are, you need to stop now because it's completely prohibited. High-risk AI systems. Now, high-risk AI is a real hot topic. We've been advising a number of clients on the extent to which the AI that they're using is likely to be categorized as high risk. I'll talk about limited risk in a minute, but the line between limited risk and high risk is really, really significant because the regulatory burden, if you're using a high risk system, is considerably higher. So we're advising a lot of people on that classification. What the Act basically says is a high risk AI system is, number one, if the AI is being used as part of or is in its own right a product that is already subject to some product safety legislation, that's going to put it into the high risk category. So some examples there would be using AI in a medical device, using AI in a child's toy. Medical devices, toys, they're already subject to quite rigorous product safety legislation, quite rightly, and as a consequence of that, for the purposes of the Act, those use cases are high risk. The Act then has an Annex 3, which lists out quite a long list of use cases, and it says if you are using AI for one of these use cases, the default position is that it's a high risk usage, unless you're able to show that under the circumstances, the use isn't going to pose significant harm to EU citizens. And that then takes you into the realms of, what mitigants, what controls have you got around the AI system's use. Now, drilling into the detail a bit more about some of that, using an AI system for critical infrastructure. So an example would be, you've got an AI system that's being used to monitor or measure or manage gas supply or water supply, something like that. That's a high risk use case. Using AI in the context of education. So a specific example would be using an AI to help you apply the admission criteria to a university, for example, to work out who should get in and who shouldn't. That's a high risk use case. Employment and recruitment. Now, this is a real live area because in our experience, a lot of organizations are already using AI in the context of employment and recruitment. And the most obvious use case, or the most prevalent use case, is using an AI to help do an initial sift of 2,000 CVs for a grad scheme and getting that down to 400 CVs for the next stage of the selection process. The AI Act says, look, employment and recruitment as a general topic, use cases within that are high risk classifications. The next ones are mainly public sector focused, so they might not be relevant for everybody who's participating in this session, but I'll cover them off just for completeness. So if you're using an AI to determine who gets access to state benefit, for example, if you're using AI in the context of law enforcement, so one use case for AI is using it to evaluate an individual offender's reoffending risk. That's not uncommon, but it's a high risk classification for the purposes of the Act. And using AI in the context of migration, asylum, and border control. So, most obvious use case there is using AI to help sift applications for visas, etc. They're all high risk use cases. Limited risk AI systems, and as I've mentioned, like that dividing line between limited risk and high risk is in our experience really key, and a lot of people are focused on that. Limited risk AI systems are they're AI, right? Because they're acting autonomously. They've got some level of interaction with humans, either because they're generating content for the humans to view, or they're a chatbot of some description, for example. Limited risk AI systems, they are AI systems, but it's just the use case and the way they're being applied is deemed by the Act to not be particularly high risk, and hence the limited risk status. General purpose AI. So I mentioned earlier this distinction in the Act between general purpose AI and AI systems. Now, the Act contains quite a detailed definition of what it means by a general purpose AI model. It's not as long as the definition I read out earlier on in a different context, but it is still pretty long. Like, in the interest of time, I won't dwell on it too much, but for the purposes of today's session, when I talk about general purpose AI, if you think about ChatGPT, Meta's Llama, Google Gemini, like the large foundation models that have got general application, that's what we're talking about, and that's what the Act means. The Act also then talks about general purpose AI systems, which are kind of built on an AI model, but I won't dwell on that too much. So, moving on from the classification of the systems, how do the rules apply to you if you are a provider? And as Matt's quite rightly said, in our experience, most organizations are deployers, i.e. users of these systems rather than providers. So I'll try and just go through this slide relatively quickly. With prohibited AI, it's really simple, right? Like, prohibited AI is banned, so you can't be providing it in the EU. It's as simple as that. If you're providing a high-risk AI system, the regulatory burden is pretty high, actually. So firstly, you've got to have a quality management system. And what does that mean? Well, that means you've got to have, amongst other things, pretty comprehensive and robust data management processes, and around things like data labeling, data mining, data aggregation. So you're really getting into the data science side of things there, but you need to have robust policies and procedures around all of that. You need to ensure that your system is complying with the technical compliance requirements under the Act. You need to retain documentation about how the system works. That kind of goes towards transparency and explainability. You need to maintain that documentation for a long time, for 10 years, basically, which I guess feels like a lifetime in technology terms, but that's how long you've got to keep it for. The EU, I think it's fair to say, likes conformity assessment procedures, likes conformity certification, etc. AI is no exception. So if you're a provider of a high-risk system, you've got to follow the Act's conformity assessment procedure, and you've got to have a declaration of conformity. And you're also going to have to register that system on the appropriate EU database. If you're providing a limited risk AI system, the regulatory burden is considerably less. You basically just need to be transparent. And whilst the transparency requirements under the Act are quite detailed, what that means in real world speak is you need to be clear and transparent to the end users of the system that they are interacting with an AI and that they're not interacting with a human. For general purpose AI, as Matt's already said, the number of organizations that are providers of these big models is pretty small. But they are subject to regulatory responsibilities. You'll be glad to hear. The first one is that they have to maintain technical documentation about the model. The next one is quite important. They have to have information available for downstream developers. So what a lot of AI development is about is effectively an AI developer taking a general purpose model and tweaking it, refining it, training it, so that it gets really, really good, not at general purpose, but at certain specific use cases. And what the Act says is, it says, well, that's fine, and acknowledges that, but it says, well, if you're the provider of the underlying model, you've got to be cognizant of the fact that the downstream developers are going to be subject to regulatory responsibilities. So you need to give them the information they need around things like transparency and explainability to comply with their regulatory obligations. If you're the provider of the model, you've got to provide a summary of your training data, how these models are trained and what they're trained on in terms of data is a real hot topic. And you've got to establish provisions. You've got to have a framework in place to protect copyright works. And Matt will talk about the intellectual property element of all of this in a little bit. If you are providing a general purpose AI model that's deemed to be systemically risky, you are subject to further obligations on top of all of that. So moving swiftly on to deployers, i.e. users, which I suspect most of you will be representing organizations who are users of AI. Again, prohibited AI is dead simple. It's a blanket prohibition, so you shouldn't be using AI in your business for any of the use cases I've just mentioned. If you're using a high-risk AI system, again, the regulatory burden is not inconsiderable. So you need to have appropriate technical and organizational measures in place to ensure that you're using the AI properly. You need to make sure that the use of the AI is subject to suitable human oversight. Now, that's really important. AI systems can't just be left to run amok. They have to be suitably overseen by humans. And really importantly, the humans have to be appropriately skilled and trained, right? Which is where the AI literacy requirement comes in. If the AI is being trained up using your data, which most AIs will be, you'll be inputting data not just to get outputs, but you'll be inputting data to train the model up and make it essentially better for what you're using it for. The AI Act says, well, the data that you as the user are inputting has to be relevant and representative. You have to take steps to ensure that. And what that's about is trying to minimize the risk of there being bias in the data, which is really, really important and is a bit of a hot topic. And you need to be monitoring and log keeping around the AI system and how you're using it. Limited risk AI, regulatory burden considerably less. You basically just need to ensure that your staff are AI literate when they're deploying it. General purpose AI, so if you are using, if you've got people in your organization who are using something like ChatGPT, if you think you haven't, bad news, like you're probably wrong, like you will have, you need to make sure that those people are AI literate. And if they're using general purpose AI like ChatGPT to give them a first draft for an internal briefing paper or something, that's kind of fine as long as your policies allow that. There isn't too much of a transparency burden that goes with that. But if they are using general purpose AI to produce imagery for customer facing adverts, for example, or text for customer facing collateral, well, then you need to be transparent about all of that. So I'll just hand over to Matt now and he'll talk through the timeline for some of these things.
Thanks, Paul. Just before I do that, and sorry, I'm conscious we didn't discuss this before the talk, but one of the things that I know came up recently with a client was that this is all a bit of a movable feast. So I think it's important for everyone watching this webinar to understand that, you know, these definitions aren't fixed in stone and your use isn't fixed in stone.
Yeah.
And so when you start to use AI systems or deploy AI systems as part of your business, what can start as, say, a limited risk can become a high risk. What can start as simple general purpose can also become high risk, and vice versa. So it's important that when you look at your internal regulation and your internal management of how you use and deploy AI systems, that you think about this and where that risk sits. I know certainly from recent discussions with kind of developers, there was concern that if a developer were to make tweaks to their system, which would take it from a low risk to a high risk system, kind of, what notification requirements they should have as part of their contract, and where that risk should sit, who should bear that regulatory burden. Obviously, from the developer's point of view, they were very clear that that is not their problem, not all the risk should sit with customers.
Yeah, that's a really good point, and it's reminded me of something that I should have mentioned. With prohibited AI, as I said earlier, we've just had a 140-page with a document guidance on that. High-risk AI systems, we're expecting guidance from the EU later on this year about that, and high risk is more complex in my view than prohibited. So I sort of dread to think how long that guidance is going to be, but I suppose the longer the better in terms of helping people get to grips with things.
Definitely, and I think the reason why that guidance I think is coming out a bit later is that, as you can see from the timeline on the screen now, the implementation of the Act is staggered. So though it was officially brought into force in August of last year, there is this stepped process by which it's being implemented. Now, as you can see, the first date at the top of that slide there has already passed. Hopefully everyone watching this webinar is now fully in compliance with everything we've just discussed. Don't panic if you're not. Thankfully, you'll see from the kind of the second date there that, crucially, any kind of non-compliance penalties don't kick in for another 6 months. So the main reason why we are having this webinar now, these things are now in force. We're now starting to get some of the guidance from the Commission about what AI literacy means. We've recently, as I say, as of last week, had our 13-page explainer on the definition of what an AI system is. So at the moment, the requirements that you need to look at and begin to get your business ready for over the next 6 months are, in relation to prohibited AI systems, as Paul made, quite a short point over. Don't use them. They're banned. If you need any help to understand whether you are using a prohibited system, that's what kind of we're here for. So do get in touch. And then the second one, I think, is the larger and more general applicable kind of remediation, which is AI literacy, getting everyone ready, getting everyone AI literate within your organisation. Now, I'm happy to say at the end of this talk, we'll briefly touch on some of the materials that we've been creating as a firm that can hopefully plug into your kind of internal know-how or training for your staff, which should hopefully make that requirement relatively simple. But it's an important requirement. And I think generally as businesses adopt AI more, and I'll come on in a second to kind of managing AI risks generally within a business, that staff have a good understanding of this, because AI systems aren't going away in the same way that kind of faddy technologies were. I'm sure we all remember the heady days of NFTs and kind of when blockchain was in the news all the time. Still important technologies, but perhaps didn't have the same impact on business and on kind of legal regulation as everyone thought they would at the time. They were a little bit of a flash in the pan. And I don't know how you feel, Paul, but I think AI is a little bit different.
Yeah, definitely.
Yeah, so as you can see from the timeline there, we've got a few key dates. So in the 6 months, you then have the general purpose AI regulations applying. So this is where you are procuring those general purpose models. Again, I think it's fair to say that we would expect that to be kind of, the highest kind of general use case at the moment. I think, you taking a third-party license of, say, ChatGPT or Google Gemini, and then slaving that into some kind of task for your business, either an internal or an external purpose. Crucially, the penalties apply from the 2nd of August. As mentioned previously, we're unsure who's going to enforce those penalties yet, as we don't have a strict regulator, but you could find yourself on the receipt of a third-party prosecution. And then, flashing forward a year, as Paul said, high-risk AI systems are quite complicated, and the regulations that apply, the Commission's still producing the guidance on those high-risk systems, which is why the regulations aren't then going to kick in, from kind of another 18 months from now. And that's also when the remainder of the Act applies. And then there is a further deadline that's pushed off into 2027, but that's very strictly related to certain safety components and probably isn't too relevant for the majority of listeners on this webinar. So, as mentioned at the beginning of this call, and this webinar even if you don't think, or you're sitting there thinking, well, this piece of EU legislation is not going to apply to us because either we're not based in the EU or we don't have any customers in the EU, in our view, the lessons that are being taught by the regulation and from the way that everyone is getting themselves ready for the increased risk presented by AI systems, are really important lessons that, nearly all businesses should be taking on board. the implementation of this new technology inside a business and implementation by suppliers and customers, is only going to create new risks. And, these risks aren't accounted for in your current contractual framework. From the contracts that me and Paul have reviewed and the remediations that we've had to put into place, this isn't simply a case of being able to fall back on the same old clauses that will get you out of trouble here. These are new risks that are being presented by, almost brand new technologies. We would expect that most businesses, either knowingly or unknowingly, are using an AI system that would fall within, the definitions as set out in the Act. Ask yourself now, do you know if your staff fully understand what tools they can and they can't use at work? Paul mentioned, using a generative tool to knock out the first draft of an email. Some people listening or watching this may have done that. And, we would strongly advise that, those kind of activities do present risks to the business. You're not sure where that data is going when it's being input into a general model. And also, where does the risk lie with regards to the output? And also, not just from an internal perspective, but from an external perspective, are you comfortable? Do you understand if your suppliers are using these tools? My role as an intellectual property lawyer, the risk around title of AI-generated materials is one that's still not been resolved either by the regulator or the courts. Therefore, if you are relying on a supplier to create you an output that you are then going to try and claim legal title over, there's quite a lot of uncertainty and risk there. And it's not just the generative materials that you need to worry about, but just more generally, if you are receiving warranties and promises from suppliers that what they're providing to you has been done in a certain way or has been done to a certain standard of quality, but through that they've used an AI system, and potentially an AI system that falls within the definition of the Act. Do your current contracts allow for that? Are you all even aware of that? These are all key questions that we think that hopefully after this webinar you'll go away and start to think about. Now, clearly the biggest key mitigation that you can deploy in all of this is some kind of contract or policy. You can see from the slide there that, when it comes to external suppliers, the key thing is going to be engagement with suppliers and looking to put a contract in place. And that's something that Paul's going to run through in a second in terms of those key areas that you can look to mitigate. In terms of internal controls, this is where we think you need to start considering, what type of internal policies you have in relation to AI, what type of internal governance you have, what's the standard level of AI literacy amongst your staff. You could put out a fantastic AI policy, but if no one understands what it says, then, its engagement with that policy and the compliance with that policy is going to be quite limited. So, these are all things that we should start thinking about. Again, these are things that we've been helping clients with, can offer support with. So if these are things that you are thinking, we really need to get sorted, then do reach out to myself and Paul. As I said, the key mitigation that we think, you need to be looking at is those contracts and how you deal with your external suppliers or even just external third parties through your contracting. And Paul's going to take you through those key kind of contractual risks and how to remediate those now.
Thanks, Matt. So one of the big things to think about in this context is consent. So are you comfortable for your service provider to be using AI systems in the provision of services and outputs to you? You might not be. And if that is the case, you should probably, or you ought to have an express prohibition on the use of AI systems in the contract. Now, I think over time, as AI usage becomes more and more prevalent, I think that would be an increasingly difficult line to draw in the sand and maintain. But that might be where you are as an organisation at the moment. And if you are in that place, you get that contractual prohibition in there. You might be fine with the service provider starting to use AI systems, but that might be based on the premise that if it drives efficiency savings, cost savings, etc., you want to share in that from a pricing perspective. Again, that's not going to go without saying. So you will need to cover that benefit sharing, continuous improvement type concepts around the AI system usage in the contract. The other thing that's really, really important from a consent point of view, and Matt's already alluded to it, is what is the data that you're inputting into the AI system being used for? Because you probably will be okay, or you ought to be okay with a position where you say, look, our data is going into the system to generate an output. it's hard to see how you're going to get that output without that implicit or explicit license for data to be used in that way. But what about training the system on an ongoing basis? The more that the system is trained, the better it'll be at whatever you're using it for. So it's kind of in your interest in a way to give a license that permits your data to be used for training and refining purposes. But that might come with strings attached, because you might want to say to the service provider, well, look, I'm fine for my data to be used to make the model better for me, but I don't want it to be used to make the model, generally speaking, better for everybody, i.e. including, people in your organizations, in your customer base that might be competitors of mine. Now, those types of data licensing issues in the context of contracts are not completely new, but the significance of them and the complexity around them is now increasing exponentially because of the use of AI systems and the extent to which they're relying on data. Compliance is a really important contractual issue. So, we're talking about the EU regulation today, but as Matt's alluded to, there's going to be some similar, but probably, possibly a little bit different UK legislation coming down the track. The US has taken its approach. China's taking its approach. So there's a global sort of regulatory patchwork of regulations developing. Stating the obvious, but you need to say in your contract that the AI system provider or the AI system user is being compliant with the applicable AI-related regulations in the way that it's going about using that system. Now, you might be sat thinking, well, we'll say in the contract they've got to apply with applicable law. That is maybe okay in certain contexts, but I would certainly encourage you to look at putting in place a more detailed compliance obligation if the AI system usage is a big component of what it is that the supplier is actually providing you with. The other thing to think about more generally from a compliance perspective is, AIs can churn out recommendations and outputs that are not compliant with the current, say, health and safety regulations or financial services regulations. And the reason you get that problem is because the AI might not have been trained up on the most up-to-date laws and regulations. So there's a compliance risk there of using an AI in that context. And then the other risk is around biased data. So, if the system is biased because it's trained on biased data, that can have negative consequences, and they can be particularly pertinent depending on the use case. So obviously, if you're using the AI in an employment and recruitment setting, the last thing you want is for that AI to be sifting through CVs on a biased, discriminatory way, and that has happened. So mitigating that risk in practice, but also trying to mitigate it as best you can in terms of contractual obligations on the provider is really, really important. Data protection, we could probably do a webinar like just on the interplay between data protection laws and AI regulation as it's emerging. These models and systems are trained on just a vast quantity of data, and often that data includes a large amount of personal data. So you need to think about how the two regimes dovetail really, really carefully. The point to make now is probably the obvious, or possibly the obvious one, that in the EU and in the UK at least, data protection regulation is technology agnostic, right? So it applies to AI usage in the same way it applies to everything else. So that is very important for data protection to remain at the forefront of your mind when you're deploying these systems. Liability, contractual liability. So again, Matt's already alluded to this. There's the liability and risk allocation is nuanced and is complex. And what I mean by that is, AIs do get it wrong. And when an AI gets it wrong, who ought to be liable? Should it be OpenAI because the AI system is built on ChatGPT? Should it be the developer who's taken ChatGPT and done lots of clever training and tweaking and refining to make it applicable to the use case that it's being used for? Or should it be, potentially your organization, which is the organization that's deploying the AI system in the wild and is actually that sort of direct interface with the end customer user? Or should it be a combination of all three? Or should it be some other stakeholder in the supply chain who is carrying some or all of the liability? This is a really complex area. And unfortunately, market practice as to what the appropriate contractual liability allocation ought to be is evolving, almost as quickly as the AI technology itself is evolving. So it's all I can really say now is, unfortunately, there's not a kind of one size fits all in terms of what's market practice. But I can say that it is something that you need to think about very carefully. The other risk associated with AI is one that is kind of difficult to manage and mitigate contractually in some ways, but it's the ethical concerns and the reputational risk that goes with the AI. I think it's fair to say that consensus in society we haven't reached a consensus on whether AI system usage is good or bad, whether it's to be encouraged or discouraged. Within that, there are a few ethical concerns that are clear. AI systems typically use a lot of energy. They use a lot of computing power, and that means they're not good for the environment. A lot of people think that AI is socially damaging. We've talked about bias and the risk of discrimination. Matt's alluded to the sort of fear that it's gonna take everybody's jobs. Other people even think it kind of represents like an existential risk to humanity. So there are ethical concerns and there are reputational risks that go with deploying AI systems in your business because of those. One of the big related risks that to a certain extent can be mitigated contractually is around intellectual property, and Matt's the IP guy, so he's going to talk a little bit more about that now.
Thanks, Paul. Intellectual property is probably seen as one of the main reasons why this discussion around generative AI or AI systems has come to the fore so quickly. As Paul mentioned, I think as an aside, there are some quite interesting questions around the ethics of the interplay between intellectual property laws and the deployment of AI systems. When we have a system based on people being rewarded for the effort and the time it takes to produce their outputs, if we're now into a kind of zero time, zero effort, but still getting your output scenario, there's some quite interesting ethical discussions there around what protection should then be ascribed to those creations. Thankfully, those are questions for kind of brighter minds than I, and for people that are far more senior than I am. So I'm here simply to tell you kind of where we are at the moment. So the use of generative AI systems, in my view, is one of the most clear or present risks to businesses at the moment, because simply it is the one that most users have latched onto very quickly. Producing the funny pictures, being able to type into one of these tools and ask it to produce you a document or a letter or some kind of output. How those outputs are then used and then commercialized or potentially licensed is the one that presents the biggest intellectual property risk. And that's because there's massive uncertainty as to kind of who owns those assets. And as an intellectual property lawyer, title is one of the biggest our biggest concerns. The establishing who owns the work is one of the biggest things that we deal with, especially in a supply chain environment where you are procuring the services of, say, a creative organization. One of the key things that you want to procure there is title to the asset. If you're going to put that out on national broadcasting advertising, you need to be comfortable that you own the IP rights in that material, because if you don't, you either lack the ability to enforce should anyone copy that right, or crucially, if it's been copied from a third-party source, you could then open yourself to a massive infringement risk. Now, there are a couple of cases currently going through the High Court in this country, as well as courts throughout the world, which are currently grappling with these questions of who owns the work. Is it an infringement to train AI systems on a body of works? And then obviously we have regulators that are also kind of running side by side. It's going to be really interesting to see who gets there first with regards to setting down an acceptable framework for how these works are managed. For now, all I'm going to say is, fall back onto basic principles, engage with your IP lawyers. we'll tell you that, the IP law hasn't changed at the moment. So basic principles apply. Whoever creates the work is going to own that work, subject to any contract applying. And, if you're worried about it, be clear about the use of AI systems. And, I can't stress it enough, get someone like an IP lawyer involved to take a look at that situation for you. So just looking at how you can generally prepare, Paul's just going to take you through kind of a quick summary of some really easy, quick steps to get yourself ready for the new regulations. And then I'm going to take you through some of the kind of the key remediations that we as a firm are potentially suggesting and offering to you.
Thanks, Pat. So yeah, the good news about compliance is it's not too late, but soon it will be too late. So what should you be doing? Well, the first thing is easy to say, possibly not easy to do. But you need to identify which AI systems you're using in your organization. It's really important that you get your arms around that. Then secondly, you need to start thinking about how those systems, if you're deploying them in the EU, would be classified under the EU legislation that we've been talking about today. But you need to think about classification more broadly, because you need to think about other, what would be the treatment of that system in the UK, in America, if that's relevant for you. So you need to start classifying the systems, and then you've got to develop your compliance plan, which is kind of getting into the weeds of the thing. Hopefully, we've got the message across today that when you're looking at compliance from an EU perspective, are you a provider? Are you a deployer? What role do you have is key. Really, really important is the AI literacy, and as Matt kind of alluded to earlier on, like this is framed as an EU regulatory requirement, but really, it makes good business sense as well, I think, to make sure that, if you've got people in your organization who are using AI, that they understand the potential risks and benefits of its use. I think that's really important. There's a compelling business case for that, regardless of what regulations may or may not say. Getting into how the system's being used and whether there are other regulatory frameworks that you need to consider. So you might be working at an FCA regulated organization. So you need to then think about, okay, well, what are the FS specific regs that are overlaying on top of this? And then what are the data inputs and outputs? What data is going into the system? What's it being used for? And what output is coming out of the system? What degree of human oversight is there on that output? And what is the output then used for? So they're all of the things that we think, or certainly at a high level, form the backbone of a pretty decent compliance plan for all of this.
Thanks, Paul. So if you're still with us, thank you. And if you're kind of scratching your head a little bit or a little bit worried about the steps that Paul just mentioned, I'm happy to say that, we're here to help. And, on the screen there is a short list of some of the kind of the tools and the outputs that we've been busily preparing or have already prepared for various clients to help them meet these various requirements. One of the things that isn't on that slide is, if anything is initially unclear, your first port of call should just be hopefully to reach out to someone. I'd love it to be myself or Paul, just for that initial conversation. It may be that in 5 minutes we can set you on the right path and we never have to speak again, but hopefully we would. And, we can talk about, some of the various things that we've been working on with clients to help them meet this quite challenging requirement. Most in-house counsel or most advisors to businesses, have a finite amount of time. So, we're not expecting you to be taking your entirety of your time be taken up with worrying about AI systems and their implications. So a lot of these tools and products have been developed to allow you to simply put them in place and forget about them. So these include, simple compliance checklists. Paul mentioned there about a very quick list about going through, working out where your areas of risk are. Following this webinar, you will receive an email with a compliance checklist attached to it for you to fill out. That's our gift from us to you. And that should hopefully get you to start thinking about, what you need to do, the systems being used in your business, and the regulatory requirements that stem from that. One of the key things that we're offering is an AI impact assessment. So if you really are just unsure on the landscape across your business in terms of how AI systems are used, how they interact with your business, that impact assessment's delivered by us. It's relatively short form. It allows us to, really quickly bring you up to speed about where those key risks sit. We've generated also a tool of AI literacy materials. So these are going to take the form of a short video, along with a couple of materials to sit alongside the video. The idea is there that you can plug those into your training and development platforms at your business, and this would allow you to meet your AI literacy requirements in a single step. We're also developing AI policies for clients. So if you're worried about that internal governance piece in terms of if your staff know when they can and can't use AI tools, we can help you there put a very quick policy in place, which will allow you to demonstrate that you are taking those steps to guide your staff and to minimize that risk. Flowing from an AI impact assessment, or you may already be aware that you are using a high-risk system, or in fact any of the classification of systems within, that classification system that Paul talked about earlier. We've done quite a lot of work already in reviewing those systems and then producing a kind of a note on what you then need to consider, both in your contracting with clients, your regulatory requirements, and the various things that you need to be thinking about if you are using those systems. So that's something that we can offer you on a relatively kind of quick basis. And then finally, kind of looking at your contracts, we've got a lot of experience based over the last few months of sitting with clients, getting them ready for the dawn of AI and what that means for them. Unfortunately, for some clients, this has come as a result of a problem arising or there being an issue. We've helped them remediate that, but that's then given us the experience to go in and suggest some kind of key changes, key supplier terms, key terms and conditions, to allow you to kind of alleviate the majority of the risks presented by AI systems. So before we leave you, I just thought I'd put the timeline slide up there again so you can jot down those dates. As discussed previously, the key one, the key factor there is that, these are already in place. You've got the AI literacy requirements and the prohibition on AI, high-risk prohibited AI systems, get my words out there, already in force. And you've got the rest that are going to flow through from that. So hopefully this webinar will start that conversation, will start you thinking insofar as you haven't already started that thinking, and you can get yourself ready for those upcoming deadlines. So, all that's left really is to say thank you very much for joining us today. Looking at the time, we won't keep you any longer. We won't do any questions. We'll pick up with anyone who has submitted questions directly afterwards. So, and also, if you have any questions that you've not submitted, please do send them through. That just leaves me to say, thank you very much for joining us today.
Thank you very much.
Yeah, thank you.